Today we are going to talk about registration of trademarks. Trademarks को register किया जा सकता है if they are capable of being graphically represented and they do not fall under the category of absolute grounds of refusal or the grounds of relative grounds of refusal. Under the Trademarks Act 1999, Section 18 to 23 and Rules 25 to 62 talks about the procedure for the registration of trademarks. Let's look at these sections and the rules. Section 18 talks about application for registration. Any person claiming to be the proprietor of a trademark used or proposed to be used by him who is desirous of registering it shall apply in writing to the registrar in the prescribed manner for the registration of his trademark. A single application may be made for registration of a trademark for different classes of goods, and services and fee payable therefore shall be in respect of each of such class of goods or services. तो अगर आप different classes of goods में apply करना चाहते हैं तो आपको उस हर एक क्लास के लिए अलग से फी पे करनी पड़ेगी with the application. Next, every application under subsection 1 shall be filed in the Office of Trademark Registry, within whose territorial limits the principal place of business in India of the applicant, or in the case of joint applicants, the principal place of business in India of the applicant whose name is first mentioned in the application or having place of business in India is situate. Subject to the provision of this Act, the registrar may refuse the application or may accept it absolutely or subject to such amendments, modification, conditions or limitations, if any, as he may think fit. In case of refusal or conditional acceptance, the registrar shall record in writing the grounds for such refusal or conditional acceptance and the materials used by him for arriving at his decision. जो registrar है, he will classify the goods and services on the basis of international classification, which is given under Annexure 2 of the Act. And next, Section 19 talks about withdrawal of acceptance, where after the acceptance of an application for registration of a trademark, but before its registration, the registrar is satisfied that the application has been accepted in error or that the circumstances of the case of the trademark should not be registered or should be registered subject to conditions or limitations. So in that case, the registrar may, after hearing the applicant, if he so desires, withdraw the acceptance and proceed as if the application has not been accepted. The next section 20 talks about the advertisement. So when an application for registration of a trademark has been accepted, whether absolutely or subject to conditions or limitations, the registrar shall, as soon as may be after acceptance, cause the application as accepted together with the conditions or limitations, if any, subject to which it has been accepted, to be advertised in the prescribed manner. So according to section 20 and by virtue of rule 43, ordinarily within 6 months, अगर आपका ट्रेडमार्क एक्सेप्ट कर लिया रजिस्ट्रार ने, then it will be advertised under the trademark general. So after this advertisement, अगर किसी को भी कोई opposition है या objection है with regard to your trademark, so they can apply to the registrar within 4 months. This is given under section 21, opposition to registration. So any person may within 4 months from the date of the advertisement or re-advertisement of an application for registration give notice in writing in the prescribed manner and on payment of such fee as may be prescribed to the registrar of opposition to the registration. After this, the registrar will serve a copy of the notice to the applicant of the registration within 2 months. After the receipt of the applicant of such copy of the notice of opposition, the applicant shall send to the registrar in the prescribed manner a counter statement of the grounds on which he relies for his application, and if he does not do so, he shall be deemed to have abandoned the application. एडवर्टीजमेंट के 4 मंथ्स के अंदर अगर किसी भी पर्सन को कोई भी ऑपोजिशन है तो दे कैन फाइल अ नोटिस टू द रजिस्ट्रार. उसके बाद रजिस्ट्रार उस नोटिस को एप्लीकेंट को देगा फॉर हिज काउंटर स्टेटमेंट. and then the applicant has to file his counter statement within 2 months, telling about the grounds on which he is relying. After that, the registrar shall serve the copy of that counter statement to the person opposing. इसके बाद there will be a hearing of the parties जिसमें they'll present all the evidences that they have with regard to the trademark. At the hearing of the parties, the registrar will consider all the evidences, and if the decision comes in favor of the applicant, then the trademark will be registered. And if it goes against the applicant, then he is free to appeal to the High Court. The High Court may uphold or change the decision of the registrar. Next, Section 23, registration. So, subject to the provisions of Section 19, where an application for registration of trademark has been accepted, and either the application has not been opposed and the time for notice of opposition has expired, which means कि within 4 months कोई opposition नहीं आया. And next, the application has been opposed and the opposition has been decided in favor of the applicant. In that case, the registrar shall, unless the central government otherwise direct, register the trademark within 18 months. The time is 18 months of the filing of the application. And the trademark, when registered, shall be registered as of the date of the making of the said application. And the date shall, subject to the provision of section 154, be deemed to be the date of registration. तो सेक्शन 23 के अकॉर्डिंग जो डेट ऑफ रजिस्ट्रेशन है वो वाली डेट होगी जिस दिन आपने पहली बार अप्लाई किया था टू द रजिस्ट्रार. आफ्टर दैट, on the registration of trademark, the registrar shall issue to the applicant a certificate of the prescribed form of the registration thereof, sealed with the seal of the trademark registry. Where registration of a trademark is not completed within 12 months from the date of the application by reason of default on the part of the applicant, यानी कि एप्लीकेंट की गलती की वजह से within 12 months आपका registration नहीं हो पाया है, तो registrar may, after giving notice to the applicant in the prescribed manner, treat the application as abandoned unless it is completed within the time specified. The registrar may amend the register or certificate of registration for the purpose of correcting a clerical error or an obvious mistake. After that, Section 25 talks about the duration, renewal, removal, and restoration of registration. So, the registration of a trademark after the commencement of this Act shall be for a period of 10 years, but may be renewed from time to time in accordance with the section. तो आफ्टर द एक्सपायरी ऑफ 10 years, अगर आपको फिर से अपना ट्रेडमार्क को रिन्यू कराना है, देन यू कैन अगेन अप्लाई टू द रजिस्ट्रार विद द प्रिस्क्राइब्ड फीस एंड द prescribed manner, and then it will be renewed for next 10 years. So this is how you can get your trademark registered for goods and services under the Trademark Act 1999.